Thank you for joining us today on this special day and a truly special occasion. We are truly humbled by the response that we have received. And before we move any further, I'll request the AV team to provide the instructions of how to use and ask the relevant questions when you have to. So request the AV team to provide the instructions. And as you would have seen in our invite, we are celebrating the 25th anniversary of our firm and other achievements, small milestones in our firm, which Nishith will elucidate on. But just to give you the procedural sort of background to this, we are going to be, before the cocktails, we'll be having two events. One is the first panel discussion, which will be on the broader aspects of M&A, and the second panel discussion, which will be on the specific aspects of M&A. Both the sessions will be moderated by Nishith and will have 5 panelists each. Now, without further ado, let me invite Nishith to deliver the keynote address. Just as a brief introduction, all of you already may be knowing Nishith. Nishith is the founding and managing partner of our law firm Nishith Desai Associates, and he's a world-renowned corporate and international tax lawyer. But more than anything, he has traveled the world and he's met several policymakers and business leaders, and I'm sure his practical insights today will be extremely helpful to all of us. Thank you. And I invite Nishith to deliver the keynote address.
Thank you. Thank you, London. Thank you. Can you all hear me? Okay. So, thank you, London. Thanks to all of you, and thanks to Law Society for this beautiful venue. I think it's amazing, and it's so historical that it very much reminds me of my old days. I think 25 years looks to us as a long history. You may have 250 years, and you have so much to talk about, so much to say, and this beautiful venue is really exciting to us for all of you to come here and join us this afternoon. So just to tell you, as you all know, that we have offices apart from India, in the US, in Singapore, in Munich, and elsewhere, but we are not present in London. And hopefully one day we will do that. But for the time being, we thought that it would be good to come here and talk to you all. We are not a very huge firm, but at the same time, we are excited by the kind of things that we had an opportunity to work on. It's now we are completing about 25 years. 25 years we already completed. 1990 was the time I set up law firm. And before setting up this law firm, I had an opportunity to study some 100 odd law firms in the world. It's a long history. I won't go into the details. But I never wanted to set up a law firm. And it was a US banker who suggested in 1984 to say that, why don't you set up a law firm? I'm a barrister. I'm a litigator in India. India, we don't set up law firms. But India has already moved to a unified system, and it gave me a thought, maybe why not? And then after I thought, but if I set up a law firm, why do you need one more law firm on the street, right? There's too many very nice law firms, long history, and so unless we can add some value, it's not worth setting up a law firm, And in the process, I said, let me look at how these law firms evolve. What are success factors? Some of the law firms that you have in this country have existed for 100 years. Great job. They must have gone through so many ups and downs, and there must be so many different success factors. So let me study them. So almost 4.5 years I did some study, met with large number of managing partners of law firms around the world, met with accounting firms, because again they've grown to a very large size and survived for a long period of time. And later I studied consulting firms like McKinsey and other ones, and so it was about 4.5 years journey from 84 to 89, and 1990 was the year when I decided to start a law firm. And two things came to my mind. That, there are many firms that have history, as I said, of over 100 years. And, I'm a new kid of the block. So what do? It's like if your father is very successful and you are starting something new, you can't match that history at least. But you can do something interesting, and the same thing maybe you can do differently. And I thought these law firms have a lot of strength. They're excellent firms, excellent partners, a lot of people to look forward and inspired by. And so I thought if they can look back with pride 100 years, in retrospect, maybe my only strength is to look forward 100 years. So if I could develop a firm based on the futuristic developments, then, maybe I can be complementary to the other law firms. So, and the whole philosophy of what we call competition also came up, cooperate and compete. At the same time, respect what they have done, build on some of the things they have already done, add some value in some of those areas, So, if I may just take a minute to explain to you how the law firm model got developed, was this. This is something that came to my mind, that, every new development in science or say technology, society, politics and economics, bring along with them a new set of legal or tax issues. So why not look to the future and see, what are new technologies, for example, are going to come in next 3, 5, 7, 10, 15 years of time. Start visualizing what new legal issues will come up. What will be new tax issues? What will be new business models? What will be new financial instruments? Those kind of things, if you begin to visualize, then by the time, actual situation arrives, you are somewhat ready, 60-80% ready. And in the process, another thing that happens is that you do work at the speed of thought. Many times what happens, new situation comes and we begin to research, we begin to look at, of course at the cost of client we do research at times, but the model that we have, professional firm today has become such that if we spend more time doing client's job, if you put more people on the job, we are more rewarded because it's all time based. But if we do the same work in less time, then often it's not appreciated and people don't get. So, many organizations, there has been some degree of distortion of behavior as well, to spend more time, put more billable hours and stuff like that. But if you want to reverse the trend as we go forward, what's the way out? And possibly this was one of the ways to do a lot more work in shorter period of time. So research became I was already a researcher by that, I would not go into details, but research became a core part of our work. So research, academics, thought leadership, we spend almost 40% of time of our firm on those kind of things today. And it has enabled us to do large deals, very complex deals in a shorter period of time with lesser number of people. And in fact, we are now nicknamed as nano firm, small firm, which thinks big and does big things. And that's how whole model began to evolve, and it's very satisfying. 25 years now that it has somewhere along the line worked. And now we are, as you can see, this is our campus in Mumbai we are building now. It's 15 minutes by speedboat from Taj Mahal Hotel at Gateway of India, and the whole campus is coming up. And so this is the main building, what we call Blue Sky Thinking Center. So it's not only law and tax, but understand entrepreneurship, the business, the spirituality, or whatever you call it. So we are building this whole thing. It will be ready sometime in the first quarter of next year. And most likely we want to do it end of the year, but I think that is the thing. And these are different facilities and whatnot. So I would not go into too many details, but whole idea is to spend more time doing thinking forward ahead, and that really became a very, very, So now we have completed 25 years of our firm. Before we set up any branch or any other office in Mumbai, we first office outside, we set up first in Palo Alto in Silicon Valley in 2000 when there was .com hype, and then after, in Bangalore, then in Singapore. And Singapore we completed 10 years. Palo Alto is now 15 years, 4 years for Munich office, and now New York is the one that's coming up. What happened as a result of this research-oriented approach was we began to become more and more innovative. And once again, as you all know, that even innovation is as relevant to a legal profession than as you may consider for technology or other kind of businesses as well. So, and as once again all of you know that last year and this year we ended up winning the most innovative law firm in India and also within Asia. And it was by Financial Times, and we thought London is a hub of Financial Times and we have not celebrated it over here. So that was one of the reasons to come here, and thank you all for all the encouragement we got from this particular city, from Financial Times and other people here. And interestingly, my specialization started with international tax and corporate law, and we began to work on different kind of transactions. But last year was particularly very good, and with all the humility and humbleness, I would say that, by merger market has ranked us as the fastest growing M&A law firm in India, with an increase of 209% in terms of deal value, and having been part of two of the top 5 deals last year. So I think somewhere along the line we have arrived, and as I said, that it's been very exciting period. We'll continue to, do our best, and let us stay in touch all the time. Whenever any of you come, first there's always standing invitation, and I would really love to have you with us. Anything we can do, we can, we'll be delighted. And most of work has been cross-border, and it's again very exciting time. Today we have 2 panels, as was explained to you. First panel discussion will provide a broad overview of the deal market in India, and the second panel discussion will be on more specific aspects. After each panel, we will open the floor for a short question and answer session. What I would like to also do is to invite my panelists before I make some further comments specifically on the M&A. Mr. Abhijit Mukhopadhyay, may I request you to come here and join us, and thank you so much. And he has been both Chartered Secretary and General Counsel now for the Invija Group of companies, which name is very familiar to all of you. And he is involved in the group's worldwide legal functions. My other colleague, Webunar+RoundTable, he's a partner in charge of M&A and private equity practice, and also holds, heads the firm's operations in Bangalore. Nishith Desai Associates, another partner who leads our M&A practice group, and there's a lot of high-profile M&As. Simone Rice, she heads M&A and competition law and private equity groups, again from Mumbai. And Ruchi Biani, she is a European operations and has been with us for a long time. Okay. Now, as you all know, last 1 year, let's say, when I say 1 year, it's almost from 2014, when Prime Minister Narendra Modi, came to power. A lot of things have begun to change. Anything? I'm sorry for that. Very quickly. And there's nothing like a perfect world, but a lot of things have changed. One of the most interesting change we have seen and personally experienced is that at least this government listens. You know, sometimes things happen, sometimes things don't. But on the whole, there is eagerness to listen to the other side of the table. And that's the first thing. I've received so many invitations and I'm involved in so many different reforms that are going on in India. I never had that before. So, you know, constantly we are now being invited to share our thoughts and things to change. And that's one of the most important thing, at least somebody listens. We have also seen quite a few changes in the whole approach, the way in which the corporate laws have been introduced. Unfortunately, and to be honest, the New Companies Act has not been that great. So there are lots of new notifications and clarifications are coming up because people have been, you know, not able to get enough clarity on the corporate law. So corporate law has been somewhat, that was introduced in 2013 and continuously there are changes that are coming up. But it's still not too bad. But other thing is on the tax side, there have been a number of changes that are coming in. Government has of course promised there will be no longer a retrospective amendment, which actually brought country down in many ways during the previous 4 or 5 years. Of course, all problems are yet not resolved. Hopefully they will be. And, you know, third thing is that new bankruptcy law is coming up. GST, most of you know that law is eagerly awaited, but not much progress is happening. There has been at times a little talk of intolerance. That is what is something which is negatively perceived at point of time. But if you look at on the whole, you know, it remains in some corners, but it has not become a national issue. It still allows people to take a very optimistic view of the country. There have been, as I said, a number of meaningful reforms that are now in pipeline. So optimism this time may be well-founded on the whole, and there are a number of reasons for that. Firstly, India is going to be one of the fastest growing economies in the world with a growth rate of 7.5% in 2016, a fact which is well documented by IMF, World Bank, economists, and other leading institutions. It is one of the bright spots in the overall gloomy global environment. Second, India has improved its position in the World Bank's ease of doing business rankings in the last 1 year, climbing almost 4 places to finish at 130. We are very much behind. At least the movement is upward, and 4 points upward is considered to be reasonably good. Not 100% satisfactory, but we see that there is so much in front of us that things cannot be done overnight. What is more encouraging is that India ranks 8th in the World Bank's Investor Protection Index, something that reflects a regulatory mindset which is now more open to the idea of foreign capital. There has been some serious reforms such as direct transfer of subsidies, rationalization of subsidies, removal of discretion for government auctions, process, and other governmental actions, e-auctions and e-procurement policies, rationalization of laws with single window clearances, establishment of commercial courts, gradual reduction of corporate tax rate from 30% to 25%, to name a few. So these are some of the changes that are happening, and the deal market has seen robust development. In 2015, there were almost 600 deals, which is highest volume in last 3 years. In terms of value, M&A declined by 18%, but this is largely because of the low value of domestic transaction as a result of lack of deal financing, stressed balance sheets, and size of some of the Indian companies, which are relatively small compared to the global peers. And of course, we have written about this issue. And if you have all the booklets, there's one booklet, small booklet called M&A Interactive. In that you will find some perspective on this. In 2015, the value of cross-border deals increased by almost 16%. In terms of sectors, energy and natural resources, IT, ITES, pharma, healthcare, rental, retail and consumer consumer goods saw the maximum deal transactions, traction. Again, coming to outbound deals, also they doubled in 2015. Sectors where we have seen increase in outbound deals are the cash-rich healthcare and ITES sectors. Also, we are seeing more interest in the real estate outside India now, because that's the first step anybody would normally take. They can see hard asset and feel about tangibility of that. This trend is also likely to continue as some of the companies have a lot of private equity dry powder and may make overseas acquisitions. India is second largest investor in the UK, along with France. The first position being occupied by the US. Similarly, UK is the third largest investor in India with 9% share of overall foreign direct investment into India. So these are some of the things that we can talk about, and this gives you some idea about what's happening on the M&A and deal side. So ladies and gentlemen, after 25 years of liberalization, in my view, India is at the crossroad. Today, what started as a necessity in 1991 to open up economy has now turned into opportunity for India and perhaps the rest of the world. So I think these are my preliminary comments, and let us begin our discussion with panelists, and feel free to chip in if you have really pressing question, and otherwise we'll take questions answers at the end of the first panel. Weber, okay, can you raise your hand so people can see you? Okay. There has been a lot of dynamic changes in India, such as opening up several sectors for FDI, new norms of stressed assets, new bankruptcy code, etc. What are the areas you foresee potential M&A, and what will be the drivers for such M&A activities?
Yeah, thank you, Nishith Bhai. I think everybody can hear me. To continue where Nishith Bhai ended, macroeconomic, I just wanted to add a couple of points on India and why this will become drivers for deal making in India. If you really look at not just Indian economy is doing well, and we hope it will continue to do well, it seems Indian government also is looking at liberalizing a lot of regulations, and we expect a lot of things to happen this year too. Also internationally, at least two key factors which I understand is giving jitters to the world, both very low oil price and the China uncertainty in China. At least what I am hearing, what the market is telling, may actually help India. Because of the strong domestic market, which is actually growing for the last several years now, and we are seeing a lot more focus on Indian domestic market, right from Indian companies as well as international companies, and that's one of the key reasons why acquisitions or deals happen in India. As well as because of the international reasons, we will see maybe more deals than what we saw last year. Some of the points I would like to mention in this regard also includes the Indian government, as Nishith mentioned, is looking to liberalize a lot of regulate or unregulate. Recently, I was a special guest at Startup India event, which was hosted by Prime Minister. And the theme of that event was be an obstacle. It was not that we will create something interesting for startups or we'll give this incentive, that incentive. The whole topic or the theme was how can we unshackle, how can we ungovern, how can we unobstacle the Indian businesses, Indian startups. And this is what is the mindset we are seeing in Indian government today. And they should mention, we are finding differences that the government is listening to us, and that is the biggest difference which we have seen, that they listen to the industry, they actually understand and they act. And they've understood that the key aspect of improving and unshackling Indian industries is basically to remove obstacles or ungovern what they were doing earlier. So we expect this year more and more regulations which will simplify process. The Prime Minister has gone on record to say that their ministry, and he has given target of maybe another about a year or so, try to bring down ease of doing business ranking from 130 what is today to below 100. And that is what we are expecting from government. The other pain point which used to be there a few years before, one massive point, whenever we used to go, people used to ask us, what do you think about corruption in India? In the last 18 months, the corruption has reduced substantially. I would not say it has gone completely. It's nowhere near standards what you would expect in UK and Europe and US. But it has at least at a higher level, it has reduced substantially. And again, at that event, Startup India event, where I was there, I had an opportunity to talk to Prime Minister. And one of the topic which came up was corruption. And he was telling us that in last 18 months since they have been government, as of now, there has not been a single allegation of corruption against the government, which is unheard of generally in India, if you look at the history of India. Secondly, he also mentioned pretty interesting thing. He said that, look, the way we are trying to tackle corruption is not that we want to take somebody and put in jail. Maybe we will do it when we can, but the Indian legal system is still catching up on that front. But the focus is how does the government simplify and reduce middlemen on any of the dealings with the government. So, one of the examples that Nishith mentioned is direct subsidies. So what the government is trying to do is, instead of giving subsidies to the government agencies, they are passing the subsidy directly to the bank account of the poor person who is eligible for subsidy, and thereby reducing the middleman. Same thing they have done in various situations, whereby they have tried to use e-governance to simplify filings so that it reduces ability for anyone to ask for bribe. So a lot of filings now are going to be online. And one of the interesting things which was announced in Startup India event is that they are going to permit incorporation company using a mobile app, which is going to come up on 1st of April. And using a mobile app, you can go ahead and incorporate a company, and their target is try to incorporate in 1 day. Now, I don't know whether they'll be successful, but that's the aim they have in incorporation of a company in 1 day. Similarly, under the new bankruptcy code which they are trying to pass, you will be able to wind down a company within 90 days. Now, in India, we always say it's easy to incorporate a company. It takes 20 days today. But if you want to wind down a company or liquidate a company, it may take anywhere between 2 to 3 years, and at least cost you 10,000 pounds or so. Primarily because it's a court-driven process, and court does not have priority for liquidating a company. On the other hand, they are trying to de-link with the court and go to the tribunal, which they have set up under New Companies Act. So those kind of processes which Indian government is doing, in my view, will help Indian companies grow faster and encourage deal making. There are a lot of new regulations or liberalization which has come in last year, which will also help deal making, which I think we will cover in the remaining panel. To come to specific sectors where we see in 2016, where we expect deal making to happen. One of the first sectors which has been good in last year also is technology sectors. We expect that in technology sectors, specifically in internet and e-commerce company, we would see a lot of deals which will happen, a lot of consolidation which will happen. The rationale for that is that in India, last 3 years, there have been a lot of venture capital and private equity investment which has gone in internet companies. And that investment has to some extent is drying up. It's difficult to get to all the companies. We are not saying the bubble has bursted, but it has become a lot more rational now. And what we perceive is that because of the paucity of funds or easy available funds which was there last couple of years, there will be a lot of consolidation. And that will drive merger or acquisitions of e-commerce and internet companies. And that would be, in my view, number one industry in India. The second, traditionally IT services has been both on outbound as well as inbound has been pretty high on acquisitions, and we believe that that will continue. We don't, at least I don't expect that to accelerate. It will continue in the same pace which we saw last couple of years. Pharma industry, again, there have been a lot of activities. We will expect this activity to increase. Where we see increase in pharma side is more on medtech side, primarily. The normal regulator, healthcare or pharma, life sciences companies, acquisitions will continue as it was last year, but on medtech side, I think it will accelerate. We will see a lot more activity this year in oil and gas, primarily because of the low oil price is going to push a lot of companies to consolidate. We are seeing activity in cement. That is the other area where we are seeing activity. Education is the area where we expect there will be a lot of activity. And as I think Nishith mentioned, there is SDR, the strategic restructuring, which is happening, because of which there will be stressed asset available. And that is where we will see deals happening on the stress asset side also. So this is, in my view, where we will see activity in 2016. Over to you, Nishith.
Thank you, Vaibhav. I think you talked about the governance. I think hopefully that happens at a faster rate, so we all can retire. Even the lawyers then would not be required for intermediation. Let me turn to Abhijit. Abhijit, you've been involved in many deals in India. Can you share your insight and experiences on some of the things that one should be aware of while doing deals with Indian enterprises?
Yeah, I think before getting into that, I may like to add something what Nishith has already said and what Vaibhav has also mentioned. We are a global business, my group. We operate in around 75, 80 countries around the world. We have got very large investments in India. I meet on a regular basis a large number of foreign investors. Now, the perception of India today is far, far positive. What I see sitting in London as compared to what it was a couple of years back. And perception in an investor's mind is extremely important. Why this is important? When we invest in any part of the world, which we do it on a regular basis, the first and foremost thing what we see as a business group, what is our perception about a country, whether it is in Colombia, whether it is in South America, whether it is in Africa. So perception is very important. Now, if you ask me, can you really prove it arithmetically? I can't prove it arithmetically. It is what is called the gut feeling. So perception of India today is much better. I still remember what one of our great CEO had told some time back. He said, unfortunately, India is always on the takeoff mode. It never takes off. Now, after that statement, today I find, especially in the last 1.5 years, that the new government is in power, India is really, it has taken off. I must say that. But having said that, all these rosy pictures, no doubt about it, but when I meet the foreign investors, they basically come up with two very micro issues which we need to address. And I know the government is addressing, but then still we have got a long way to go. When I say that, do you know that this government is discarding 1,700 archaic laws? They say that's fine, but still we find the new laws are all being done to a great extent through ordinance, because your parliament does not function, and in the upper house of parliament, the present government does not have the majority. So therefore, that's a big problem. So if you don't address those issues, which I know very well, as someone who is dealing with the government in a very large scale in India, the government is addressing, but its hands are also tied up. So this is one issue that when I address the foreign investors, they come up with. You look at the recent laws also. Now, most of the laws are so good in nature, but they have come in the form of ordinance, and the foreign investors always tell me, these ordinances will be lapsing in the next 6 months. So what do you do after that? I can't blame the government for that. If they don't have the majority, then of course there is a problem. The second problem which I am always confronted with is the dispute resolution process. Arbitration is yet to pick up in India, unfortunately. It is still the traditional court process. This is in our all DNA. If there is a dispute, let's go to the court and settle it once and for all. Now, arbitration, as I said, is really nowhere to be seen. I am a part of ICC Paris. I am the vice chairman of ICC's Commission on Arbitration and ADR. We make the rules for the ICC arbitration. And recently we have taken steps to promote arbitration in general and ICC in specific in India. But we are finding that still we have got a long way to go. In the Western world, when we do business, there is no question of any code that anybody talks about. It is always arbitration. But unfortunately in India, it is not so. So this is something which we need to address when we are talking about ease of doing business in India. I am not getting into the nitty-gritties, the Supreme Court decision, how they messed up, the India arbitration, what is the situation now. Things are much better. We have got a wonderful arbitration act. In nowhere it has been written in any parts of the world that an arbitration dispute can be settled within a specific time frame. Nitish talked about a wonderful Companies Act, but then it also requires changes. When I look at the Indian Companies Act, corporate governance with the rest of the world, I think we are far ahead of everybody. But then the issue is that we also got to be a little bit realistic on that. So these are the two things I thought I'll bring it to your attention. Nothing negative in that, but then certainly this is what the foreign investors want. Coming back to, having said that, I can't resist myself in giving one example. We are setting up a $2 billion power project in India. The one unit is already working, and the next unit will be working in the next 2-3 months. Synchronization is going on. When we faced problem and when we met the power minister, I'm talking about the new government, Vaibhav, you talked about the middlemen. Delhi is crying because there is no middleman in Delhi. So therefore, they are literally, there is a big vacuum that has been created in Delhi. There is no middleman. When we met the power minister, he heard us and he said, what exactly you expect me to do? And we said, sir, can you help me in this? He picks up the telephone, talks to the managing director of a power company, a public sector power company, and said, look, now I have brought two of you, Hinduja group, as well as you, together. My role is over. Hinduja group, you come back to me in the next 2-3 months. If you don't get cooperation from the public sector, here is my business card. The minister is giving us the business card. This is my email ID, and therefore you write to me. Now, this kind of changes, at least we have not seen in the past few years in India. So that shows the kind of changes that are being made. I was hearing the commerce minister a couple of days back, and she said, do you know somebody asked her, what is your biggest challenge? She said, my biggest challenge is not my work. My biggest challenge is how to cope up with the work of the Prime Minister. The man who works 18 hours a day. So therefore, the expectation is that we will all work 18 hours a day. So this is my challenge, although I am 20 years younger to him. So that gives you some flavor how India is changing. When I sit here and meet people around the world, they always say, but we are not seeing those changes on the ground. Now, obviously, it takes time. I was reading an article in Times of India, Financial Times here, and they said that the Prime Minister is changing India by attacking the micro problems. He goes, addresses the bureaucrats and say, come on time. Now, you may be finding that pretty, humorous, but there is no humor. Because earlier, the people were not available when you go and meet them. Most of the time, they are not available. Today, in many corridors of powers in Delhi, there are microchips available and electronic attendance of record, and I can sit here and find out today in Ministry of Industry or Ministry of Defense what is the attendance rate. So therefore, something unbelievable. So he is attacking the micro level problems, and when this will be sorted out in the next couple of years, we are pretty sure that the country and the foreign investors will really see the growth in India. Coming back quickly on what Nitish has said, that what are the things that you should keep in mind while doing deals in India? I think there are many things. I would not like to touch all the areas, but I will take one or two areas which I thought would be quite important when foreign investors go and try to make deals in India. One area is the cultural area. And when I say cultural area, it does not mean that really there is a large difference between human beings, whether they are coming from the West or they are working in Asia. But the finer aspect of cultural issues is something which, as someone involved in business deals, you must be aware of. Sometimes I find people complain, you people are so slow in decision-making process. Now mind that in India, there are all kinds of businesses, what we don't see in the West today. Many businesses, and the majority of them are managed by families. Even my own business is ultimately managed by a family. So therefore, in India, when I worked almost for 15 years, I was the general counsel and company secretary of 6 major multinational companies in India. I have seen, I go to the board, I take a decision, and then it is approved by the board or it is approved by the CEO. Whereas, if you are in a family level environment, you can't expect the same thing will happen, especially if it is a joint family who live together like us. So you got to be a little bit patient. You got to understand the decision-making process in a family business, whether there is a big family or small family involved. That is something you should be very careful. Second thing, the other aspect of cultural issue is that culture is all different. I was talking to one of my colleagues in Brazil, and because a conference call was organized and nobody turned up at the appointed time. And when I asked him, he said, Abhijit, half an hour gap is nothing basically. So if we say it is 10 o'clock, you don't mind, even you can join in 10:30, it doesn't matter. There's no disrespect to my Brazilian people or my colleagues. In India, I'm not suggesting that by telling 10 o'clock the meeting will start at 10:30. But then, as for the Western world, if you are expecting I am there bang on time, 5 minutes before 10 o'clock, and how come nobody is available? Don't get surprised, be a little bit patient, and please understand that people will come up on time. On the cultural issue, we have seen when we discuss business deals in the West or in the US and other places, they are pretty systematic. Immediately they come on the business and then the agenda starts. Whereas in India, it may take a little bit of time. So culture is one issue. You should be careful. Even I'm not going into the details, whether you should shake hands or whether you should not shake hands. How do you address the ladies? That itself is a big question mark. So therefore, I thought I will address only the cultural part of it. Rest of the things, I think you need at least 2 sessions to talk about.
Thank you so much. I think it reminded me as you said, it's not a humor, but in India, headlines are that now bureaucrats are coming on time. I think that became at one point of time, and I think that was very, very important. Nishal, may I just ask you to make quick comments on what are the options to structure M&A deal in India? If you can be a little quick, that would be helpful.
Sure. So before I get into the various structures which we have seen for structuring deals in India, I think it's important to understand which are the most important laws which need to be kept in mind while structuring a deal. So primarily there are 5 laws which one needs to keep in mind. The first one being the Income Tax Act, and as you know, Vodafone became more popular in India because of the tax controversy than compared to the mobile services it was giving, rendering in India. Similarly, the second law which is more important is the Companies Act, and just like in UK, the Companies Act was implemented in phases from 2006 to 2008. In India, as Nishith mentioned, the Companies Act 2013 is also going to be implemented in phases. So currently we have certain sections of 2013 Act which are effective and certain other sections of 1956 Act which are effective. So we need to really see at times, what we have also seen is that a particular subsection of the section is effective, but the section of the other act is effective. So there are a lot of issues currently which are there under the act, and as Nishith mentioned, we keep seeing new things coming up every time on the amendment to take care of the issues which were there under the earlier act. Third important law is the exchange control regulations. The Indian rupee is not fully convertible on capital account, and hence any foreign investment into India or Indian investment outside India is subject to certain restrictions under exchange control. The fourth important law is the securities law, where if you are doing a public M&A, you need to adhere to takeover code, insider trading, ICDR for preferential allotment of shares. And just like UK, we also have, as I mentioned, we have the takeover code, where in case of UK, if you cross 30%, you need to make a tender offer for acquiring the rest of the shares of the company. In India, we have that threshold of 30% is 25%, and we are not required to make tender offer to all the shareholders. It's only to 26% of the shareholders of the company. The fifth law and the most draconian law is the Competition Act, where the penalties are huge for even a small failure in notifying the Competition Commission about a transaction, even though that may not be resulting in an appreciable adverse effect on competition. So these are the 5 major laws one needs to keep in mind while structuring a deal in India. But more important, before I get into the structures, I think it's very important to understand how the structuring has changed in India in the last decade. 10 years back, what was followed was more form over substance. The structures were devised keeping the letter of law in mind, and the regulators were not very vigilant to look at the structures the way they were not meeting with the spirit of the law. But what we have seen in the last 5 years, if you see the tax department, Foreign Investment Promotion Board, Reserve Bank of India, and various regulators, they have started looking at the spirit of the transaction. So no longer cute structures work in India. The threshold that we apply to all the structures while advising the client is, if tomorrow this structure is on the front page of the business newspaper, will you as a client feel good about it or not? And will you be able to defend it or not? So that's the threshold which we are seeing, and even the innovations which are happening on the structuring side are more on simple innovation rather than complex innovation, because the biggest problem with complex structures is you as an advisor may understand the structure, the client may understand the structure, but ultimately you have to defend the structure in front of the court or an arbitrator or a regulator, and they may not understand the complexity with which the structuring was done. So it's important to keep the structure simple, and optically the structure should look simple and clean, especially for large deals, because the risk in large deals is much higher than the smaller deals. As far as the structures are concerned, just like you guys have in UK, we also have typically 3 types of acquisitions: share acquisition, asset acquisition, and acquisition through merger. Between share acquisition and asset acquisition, The sellers usually prefer share acquisition because the taxation for the seller is lesser as compared to asset acquisition. Between share acquisition, asset acquisition and a merger is the most effective from a tax perspective because mergers are tax neutral in India. So if there is an option to merge the company, that's something which we have seen being followed. One important thing to note is India does not allow outbound mergers. So while a foreign company can merge with an Indian company is not allowed to merge with a foreign company. So that's something which is important to be kept in mind. The places where we have seen asset acquisitions happening as compared to share acquisition is more from a buyer perspective. Sometimes the buyer may want to cherry pick the assets as compared to taking the entire company as a whole to ring fence it from the company liability. Second situation where we have seen asset acquisition structures is in case of listed company situations where you want to acquire a major business of a listed company, but you don't want to go through the entire process of going through an open offer and then maintaining the listed company in India. In that situation, we have seen the listed company, doing an asset transfer of its major business to the Indian subsidiary of the foreign acquirer. And this is something which, that trend started more with the Abbott Piramal deal, where Piramal Healthcare, which is a listed company, sold its healthcare solutions business to Abbott's Indian subsidiary. And the way it was structured, there was no need to make any open offer to the public shareholders. So that's another reason why we have seen a lot of deals being structured as asset transfer. Third reason we have seen is some of the acquirers, they want the step up on the cost of acquisition. Now, if you acquire shares of a company, you don't get the step up on the assets of the target company. So, but if you are doing an asset acquisition, you can allocate higher values to the assets of the target company. That way you can claim more of depreciation benefits as an acquirer as compared to a share acquisition. So broadly, it's more or less the same as you have in UK, share acquisition, asset acquisition and merger. Some of the innovative structures that we have seen in the M&A space, one is on the earn-out. Now, just like earn-outs are common in UK and other jurisdictions, in India also earn-out is quite standard, where you pay certain consideration upfront, and the balance consideration is linked with profit performance of the target company over the next 2 to 3 years. And the biggest challenge with structuring earn-outs in India is in case the acquirer is a foreign investor, the Reserve Bank of India does not permit a foreign acquirer to pay deferred consideration without the prior approval. Now, which means that you cannot acquire 100% shares on day one and just pay 70% of consideration with 30% consideration being paid in future. That's something the Reserve Bank of India doesn't like. So the way we have got around this is what we do is 10% is the threshold for minority shareholder to get rights for operation and mismanagement against the majority shareholder. So what we do is the initial 70% upfront consideration is paid against transfer of more than 90% shares in the target company. So let's say you take 91%, acquire 91% shareholding upfront, and the earn-out is linked to the transfer of balance 9% shareholding, which means that you are not paying any deferred consideration. Every time you are paying a consideration, there is a corresponding transfer of shares, which is in compliance with the Reserve Bank of India regulation. So that's how we have structured earn-outs in India till date. The second interesting structure which we have done, where we have flipped a lot of e-commerce companies outside India, is where you flip the holding company of an e-commerce tech company from India to outside India. The benefit of this are multifold. As all of you know, the capital markets in India have been down for the last 5 years. So a lot of these companies feel that the market, in case they want to list their shares, is not in India, it's outside India. So it makes more sense to have a holding company outside India and then list or offer the shares of that holding company on NASDAQ or NYSE or LSEM and get the benefit of better valuation outside India. We have also seen, because of the exchange rate volatility, which as you know, a lot of private equity investors invested in India in 2007-8 when the dollar was 42 rupees. And today the dollar is about 65, 66 rupees. So almost 30% of their investment got wiped out because of the exchange fluctuation. And to address that issue, what we have seen is more and more private equity investors are preferring to invest in an overseas company with an Indian business as compared to investing directly in India. So they invest in dollar and they exit in dollar to avoid the exchange fluctuation risk. Another advantage of a global holding company, outside India, is you get the benefit of borrowing cheap at cheaper rates outside India as compared to borrowing at higher interest rate in India. So this is another structure which we have seen where you externalize the company outside, and there are a lot of other advantages attached to it. But a lot of e-commerce and tech companies are looking at this structure. One of the other new change which has just come in a couple of months back is the government has allowed foreign investment in limited liability partnerships under automatic route, as long as the sector is not part of the financial services sector. So what the structure that we are devising right now is the biggest problem with a lot of IT companies are facing in India today is you have a foreign parent and you have an Indian subsidiary which does all the development work. Now, because there is a service which is rendered by the Indian company to the foreign parent, you need to comply with the transfer pricing norms. And as per transfer pricing norms, there is a cost plus markup which needs to be charged, which means there is extra cash and profits which get accumulated in the Indian company. Now, the problem with the Indian tax laws is that the moment you distribute dividend from India to any shareholder, the Indian company has to pay a dividend distribution tax of 20%. What this means is that if there is a cash extraction which needs to happen from India to outside India, you have to pay 20% tax in case the subsidiary is a company. Now, with this new liberalization where the government has permitted LLPs instead of companies to receive foreign investment under automatic route, the same Indian subsidiary can be either converted into an LLP, or you can do a asset transfer from the existing Indian company to an LLP, which means even though there is a transfer pricing which could apply, the LLP can freely distribute dividend back to the parent without any dividend distribution cost in India, because unlike companies where dividend distribution tax is applicable, LLPs are not subject to that dividend distribution tax. So that's another innovative structure where we are working with few IT companies to address the cash repatriation issue outside India. And the last major change which has been announced in the last FDI policy amendment has been on swap of shares. Traditionally, India didn't allow swap of shares without prior regulatory approval. For every transfer of share, there was a corresponding exchange of cash which was required. Government has liberalized this, and in the last amendment to the FDI policy, the government has mentioned that swap of shares does not require any prior regulatory approval, which means you can use stock as a currency and you no longer need cash to be paid for transfer of shares. So these are some of the major amendments and structures which we have been seeing of late based on the recent amendment.
I think that brings me to Simon, and could you tell us some new trends in terms of deal structure that you are witnessing?
Sure. So I think in India, deal structures sort of adapt to change in law and change in economic environment. Originally, when people invested into India, they were skeptical of acquiring control. So most people went into a company in scout of a promoter, and there was over-reliance on the promoter, really speaking. So a lot of emphasis was not just to find a good target, but to ensure that the promoter, that's the controlling shareholder, could take management decisions, and you relied heavily on that promoter. There has been, however, a change now in terms of how acquirers are perceiving Indian companies and are looking towards sort of acquiring control and taking control positions. One specific trend that has happened in the recent past is, new age companies coming in, where the promoter really sort of needs to earn his equity. And maybe because of a series of rounds of investments has been significantly diluted, which means today that the promoter reliance goes down. So control deals are coming into India, where foreign acquirers are no longer sort of skeptical in acquiring control. The second thing that is now sort of opened up control deals is in the listed space. the question has always been for India is valuations. Today, when a promoter wants to sell a company, the question is whether the valuation of an Indian company is really realistic, or is it just inspirational, aspirational for the promoter. And therefore, sometimes when you want to acquire and be sure of its value, a listed company may serve as a better benchmark because of market pricing. The question that consistently arises is, sort of how do you acquire control? Is the takeover code too onerous? Do you necessarily need to buy from the promoter? What happens if you're acquiring, if the promoter only has a 40% stake? I think a very good example would be the USL-Diageo deal, where Diageo wanted to acquire USL and struck a deal with the Malia family and benchmarked the control element to acquiring shares in the open offer. Now, unfortunately, the open offer turned out to be a failure, and therefore, even though they had originally benchmarked a control deal, this didn't really happen. Changes in law now sort of, and one reason why the open offer sort of failed was mainly because of tax concerns. Now in India, today, if you sell a share on the market, there is no real long-term capital gains. You only have to pay STT. If you sell the shares off the market, a listed company share off the market, you still have a capital gains impact. And therefore, when you made an open offer and wanted to acquire shares from the market, acquirers would have to pay long-term capital gains because it was not deemed to be a sale on the market. The regulators now have changed that, which now provide the acquirer who's making an open offer the ability to acquire shares from the public through the stock exchange mechanism, which makes it more sort of favorable. So we're going to be seeing, likely to be seeing sort of control deals through the exchange mechanism take place. The second sort of new phenomenon that has happened in the recent past is strategic debt restructuring. Weber, you touched upon it a little bit, but it's interesting to see what the Reserve Bank of India is trying to do with the NPA sitting in the country. In an effort to ensure that banks clear up their balance sheets, the Reserve Bank of India is now sort of pushing banks to convert their loans into equity, and then they have a fixed period to sort of sell that asset to a new controlling shareholder who would take care of the asset in sort of a new form of M&A that is happening. I think the most talked about one is Electro Steel, where one of the last two sort of bidders, one is Tata Steel and UK's First International. So let's see how that goes, but that's providing a new opportunity for M&A in India. The third new sort of trend in M&A is a regulatory form of M&A. Nishith talked about the Competition Act and how it's a draconian law. We've seen sort of only two phase 2 investigations in our antitrust merger filings. Both have resulted in asset divestments by companies, and that seems to be a new trend in acquiring good assets because of a regulatory issue. I think the fourth sort of trend in M&A today is a management buyout. It differs from what the world thinks of a management buyout, because it's not necessary that the management would have a specific economic stake, but since reliance on the promoter is diminishing, the management is considered to be more important, and taking over entire management and having that control versus ownership distinction is something that we're looking at as a new set of a new trend emerging in the Indian market scenario. And I think the last but not the least is the going private transaction. Now, acquiring a listed company, large companies today in India are typically listed with good value. Acquiring a listed company always has the problems of the takeover code, and the question that consistently arises is that if I want to take it private, how do I do it? Is it sort of simple? Our delisting regulations were quite onerous, mainly because of the way the pricing methodology had to be sort of computed. The new laws now, we've seen you know, a new spate of laws which make it far easier for companies to take for acquirers to take a listed company private. And you know, I think the latest one that has gotten completed is SR Oil, where we've seen that the actual delisting process just took a month. So you know, with these sort of changes in laws and changes in the economic situation, we see new types of deals, new sort of avenues for M&A to actually grow.
Thank you, Simon. I think, may I request Ruchi? Ruchi heads our Munich office and looks after the European operations. And after that, we'll take questions as well, because that's more important to hear people from the other side. So, Ruchi, you've been assisting many Indian clients in their acquisitions in Europe. What are the key structuring aspects or issues that Indian companies are focused on, and how they have been addressed?
Yeah, sure, Nishith. So, as Nishith started in his keynote speech, we've seen outbound M&A activity from India gaining momentum in last few years. And there has been considerable change, not only in terms of magnitude, but also in terms of the sectoral composition or the geographical spread. As most of you may be aware, Indian companies are typically not market seeking, but looking for any kind of strategic asset, maybe a newer technology, an international brand, or a client or a distribution network. And typically we had seen more M&As or outbound M&As happening in, of course, acquiring a strategic asset, but more in the IT and the pharma space, typically in Europe and in US. But over the last few years, we are seeing that the trend has changed. We see across a lot of sectors like the mineral resources, natural resources that has been tapped by Indian companies to make acquisitions. A lot of designer companies, tech companies again been picked up in US particularly to make an outbound acquisition. So there has been considerable change. Just to give you a background, the outbound M&A activity from India actually gained traction in 2000 with liberalization of our exchange control regulations. And it was basically in 2007-8 where we saw, it was at all-time high, where we saw mega deals being done by Indian companies on the lines of Tata Chorus or Hindalco Novelis or Suzlon RE Power. So that was at all-time high, but the activity has slowed down considerably due to several factors such as the global meltdown or economic conditions in India not favoring outbound acquisitions. However, with things in India improving and the balance sheets of Indian corporates becoming stronger and stronger, we see intense activity on the outbound M&A space as well. And in fact, rarely there's a week without any item in the business news about yet another Indian company making an outbound acquisition. So it is equally intense on the outbound M&A space. Typically they are in mid-market segment, so it's not in millions and not in billions what we see, what we had seen in 2007-8 days. Moving on to key structuring issues and aspects that Indian companies are focused on. It's important to be mindful that the Indian legal framework plays a very important role in setting the stage for outbound acquisition. So there are a lot of Indian exchange control regulations and corporate laws that place a lot of restrictions on Indian companies to make how the transactions will be structured or in terms of the future potentials for Indian companies to make an outbound acquisition. Just to give you an example, India has exchange control regulations when it also is concerned for making outbound acquisitions. So we have something called as the overseas direct investment, which prescribe a ceiling limit up to which an Indian company can make investment or a financial commitment outside of India. And currently the ceiling limit is around 400% of the net worth of the company as per the last audited balance sheet. So this definitely defines or lays down the size up to which an Indian company can make an investment. And irrespective of the ceiling, if there is an investment or a financial commitment which is more than $1 billion US, then it requires prior RBI approval. So it is very important to be mindful of the legal framework which imposes these kind of restrictions. Vast majority of structures of outbound acquisitions are more in the form of friendly all cash acquisitions. Now this can be due to a variety of reasons. Of course, use of cash as primary form of consideration for outbound acquisition is not surprising because Indian companies are cash rich. And of course, like Abhijit was mentioning, they are family owned businesses. So typically promoters are not, there are concerns in terms of giving stock entering into any kind of share swap because of dilution in equity. But apart from the economic or the business considerations that influence the structure, there are a lot of other regulatory hurdles. For example, like Nishith mentioned, while there has been liberalization when it comes to investment by way of share swap in an FDI transaction, an investment by way of share swap in an ODI transaction is still subject to an approval. So there are regulatory hurdles when implementing any kind of deal through a share swap. So what typically we see is an SPV, a special purpose vehicle, being set up outside of India because it is easy to raise capital outside India because these companies have existing cash reserves and I mean they are a subsidiary of holding company having existing cash reserves and low leverage. So it's very easy for Indian corporates to raise capital outside India. Set up a subsidiary outside India, provide an equity financing, and then this special purpose vehicle typically raises any kind of a senior debt or mezzanine funding in order to make an acquisition. So that's a typical structure that we see in terms of setting up an SPV outside India. Other key structuring issue when it comes to outbound acquisition is, like Nishith was mentioning, doing any kind of an acquisition by way of an outbound merger. So the Indian law does not allow Indian companies to merge with a foreign company, while that's part of the law, but that has still not been notified as of now. And also when it comes to any foreign company merging with an Indian company, it's subject to a cumbersome process which is going through a court approval and almost following like a 4 to 5 months process. So typically we've also not seen inbound acquisitions in form of mergers with foreign companies. Apart from that, an important issue that needs to be kept in mind is the labor issue. As you may be aware, in the Apollo Tyres or Apollo Tyres acquisition of Cooper, which was like a 2.5 billion acquisition announced in 2013, had to be cancelled because of labor strikes in the US and China. So it's also becoming equally important to keep in mind whenever you are looking at an acquisition and in which the labor force is an important stakeholder in the M&A space. I think that's it on the key structuring issues when it comes to an outbound acquisition.
Well, thank you so much. Just a little word on structuring. I think for a long time we have all been talking about structuring, right? Time has come to think in terms of architecture rather than structure, because structure, like structural engineer, has a very hard, clear aspect to the whole thing. But today you must not only do things right, but it must look aesthetically good. It must feel good. Otherwise, whether tax authorities or any other authority will pick up, even the newspapers can pick up and make it an issue. So it's very important to understand that even if you are doing things right in an accurate fashion, but it can still lead to a problem. I think we have seen that same thing in the UK as well, but in India more so. So that's something which is very important to bear in mind, because if you only look at the letter of the law, then perhaps things are not happening as you might expect. Second thing is, structuring. A lot of people go on whiteboard or a slide and say, okay, this is a structure and this is how we should do it. The real art lies in how you translate your structure into a documentation. That's where we have found a lot of difficulties at times. People who do not exactly articulate the whole structure in a documentation. That's something which is very, very important. And third important thing is that every time you do a documentation, you make your recitals, recitals contain a good story, because that's a starting point. Normally we do not pay often that much attention, perhaps in the UK you paid a good deal of attention on that. But it's very important the background in which you are actually drafting a document or doing a structure or whatever it is. If that can be put in the form of your recitals, you have to explain less to the authorities. Otherwise, when any document is questioned or challenged, then at that point of time you start explaining what is the background. Now by the time people may have changed, things may have been different. So if you explain your story as to why, what is the background, so recitals is a very important part of every documentation today. So I think these are some of the things that I would add to what you all said. And I think structuring is very, very important. And but again, all of us know that structure follows strategy. In management, strategy doesn't follow structure. So you have to integrate three things: strategy, law, and tax, and then work towards the structure. So it is not that just you put in place a structure, because we all lawyers are good at complicating anything that is given to us. But it's important to bear in mind the strategic objective. One thing I have found, if you see 60-80% of mergers and acquisitions today, they are all IP driven, to acquire some IP, by and large value transactions. Hard assets are there, but I think by and large the bigger things, and there are more intangible issues. So there are problems are also intangible apart from the property being intangible. Same thing in international tax. 60-80% of the issues that we find relate to the intangibles, and many times we as good tax lawyers, go ahead and start doing things, but without understanding whether, for example, patent is a positive right or negative right, or is a, and what does that actually mean? What does an IP mean? And again, transfer pricing, intangibles is becoming a very critical part of the whole thing. So intangibles, as I said, in international tax, we have seen a lot of issues around that: royalties, fees for technical services, and so on and so forth. And of course, another 20-30% issues in tax relate to permanent establishment and issues like that. And then 10% is like, shipping, aviation, and all those kind of issues. But 70, 80, 90% of the issues relate to IP and agency principles. And that is very important for people to, bear in mind. Otherwise, the whole strategic objective is lost, and you do a great structure, but it really doesn't achieve any result. So these are some of the things that I would like to.
Can I just add?
Yeah, sure.
For a minute?
Please.
I think in this country there is a lot of social pressure. I'm talking about the structure part of it. There is a lot of debate going on. Forget about the law, whether it is really ethical and moral for the companies to make profits in a circuitous way, although it may be permitted by law. Recently, just a couple of days back, you must have seen that eventually the Chancellor of the Exchequer and the Google, they have sorted out, and for the last 10 years, whatever Google has done and what kind of profits they have made, they have agreed to pay 130 million pounds. Just think of last 10 years tax is 130 million pound of Google, whose yearly turnover is no less than 40 to 44 billion dollar. But a beginning has been made. Second example, there is a lot of debate when it came out that Costa or Starbucks, they almost don't pay any tax here. And people started boycotting their product. Even in small villages, people did not allow the Starbucks to come in. They said that we will not allow. So there is all kinds of social pressure that is going on. There is a lot of debate going on because Facebook pays 4,000 pounds as tax. It is so ridiculous. So the short point I'm trying to make is that there is a lot of social pressure going on. In the UK, the government has come up, I'm sure Nitish is an expert on tax law. From 1st of April, there is something called diverted profit tax, DPT. So if you create a structure which is otherwise legal, but it can be proved that you have created just to avoid payment of tax in UK, then you are caught under the DPT. And it is for the business to come up and find out whether they are violating the DPT or not. And if it is found that you are violating the DPT, then you are paying straight away 25% tax as against the corporation tax of 18%, which will happen very, very soon. So this is something what I think India should also take note of.
Yeah, thank you so much. I think we have talked a lot. It's high time we listen to you all here. So we would love to have comments or questions or anything that you might want to, Any comment or question? Otherwise I can.
Can you hear me?
Yeah. Can you please tell your name and organization?
Sure.
So
It's
a bit louder though.
It's Mahinder Khare. I'm an international accountant, connected with India in two ways, born there and also trying to work with the Institute of Chartered Accountants of India in terms of helping professionals understand as to how one can possibly join hands with professionals. Now, we seem to understand that India is still a cash economy. My question is, number one, how does the Black Money Act fit into it? That's number one, which I believe became effective last year. My second question is, the mindset of the Indian taxes inspector is probably still slightly outdated. While there are liberalizations, there are legislations which seem to allow you, we still find very difficult in understanding the civil servant side of it. I accept it is slow. And secondly, the point here is, do you think that increase in the GDP amounts to increase in the per capita income? If so, how much has happened in India in real terms?
Okay, quickly, as far as Black Money Act is concerned, that was introduced, after the HSBC and other things that had happened to compel Indian people who had money abroad so that they can bring it back, and the very harsh penalties were provided, like 10 years imprisonment and so on and so forth. It has not really worked that well. So, people have begun to even forget about that whole law. I believe they allowed some kind of a disclosure. I think they collected, I don't know, 500 million or something like that, pittance, and the whole exercise. But there was big noise about the whole thing. One consequence of that was that a lot of honest people who had legitimate assets abroad, they were a little scared off. Many non-resident Indians who returned to India and they had accounts abroad, and if they had no problem in paying taxes, but disclosing all the global assets and everything, and whether it's painting or this or that and everything, that really scared them off. So a lot of people migrated outside. So I believe Dubai alone issued some 100,000 permits, residency permit. So a lot of people have moved out to Dubai, Singapore, some people back to the US, and some have come back to the UK. And, so black money really has not solved any problem, to be honest, and it has just scared away people, and that's one thing. Second thing about the mindset of the tax inspectors or tax officers, as you call, very interesting question. What had happened and what has changed now? Okay, what had happened was that tax officers had inherent, incentive to collect taxes without any legitimate authority. Okay, why? Because the promotions of the tax officers were linked to the collection made by them. irrespective of the fact whether right or wrong, if the amount has to be refunded later on, doesn't matter. So, the promotions were tied, and the incentivization scheme was all that, okay, you collect taxes. So many a times you must have heard corporates coming to you, and tax officers will call up and say, okay, it's month of March, please pay some tax, my promotion is held up and otherwise it will be a problem. I know we don't have a good case. You'll get a refund with 6% interest, okay, but please pay tax now, So these taxes are paid, and then, it was a big nightmare for most of the companies. I spoke about this to the finance minister, and also Prime Minister has just made a statement that now the incentive would be linked only when his claim is sustained in the highest court of appeal, if at all. Otherwise he wouldn't get. So that is the new thing that is coming up, and hopefully that will dissuade the tax officials from taking very aggressive stance. And I think other thing, they are going to also look at the quality of the assessment orders they pass. At the tax officers level, it was not unusual to see 1,000, 2,000 pages orders as well. We are not surprised. Now we'll be surprised as to how come he can write, but he would write like a long Supreme Court judgment and quotations from all the judges and stuff like that. It was not really necessary because he wanted to show that he has really done a hard work. Except quoting all these judges, nothing much was done. So this is one important change that has come, and we expect a lot more e-filings and electronic system that are being put in place that will also, ease the process. Now, I was told recently that people have suddenly started receiving a lot of refunds, and very, very, very fast, which was quite unheard of earlier. But that whole thing is undergoing change. So there are some changes we have seen in the recent times. Yeah. So I think these are the two comments for the time being. Anything else?
So just to add also on the cash economy, I think that's something that even in the last finance bill, Finance Act, I think efforts are being made to sort of reduce the cash reliance in India. So two important aspects that are contributing to this. One is the fact that India is going to see 20 new banks in the next year. They're divided into payment banks and small banks. The idea of this is penetration of bank accounts throughout the country. So that's one. And second is in terms of reliance. If you see the finance minister's speech last year, they were talking about incentives for using sort of electronic card transactions as opposed to cash transactions. But I think the first step was to ensure that people really had bank accounts to sort of to see what other efficiencies can be brought about. So we're likely to see something more recently. And third, I think someone on the panel said, they're cutting off the middleman to ensure subsidies reach the account of the beneficiary directly. So I think that is again sort of ensuring that the middleman or cash transactions are eliminated to a large extent.
The other thing is that the visit of the factory inspectors and troubling the companies, these have become now a thing of the past, because it is a self-certified return these days. You need not have to get the factory inspectors to come up, have an inspection, and then report it to their higher authorities. So that is also cutting down corruption to a great level.
Any other comment? Any other question? Okay. So I think, let me, I believe any comment? Sorry for that. Please tell your name and organization.
Yeah, this is Sandeep Biswas from Mitchell Moss. My question was, you mentioned, I think it was mentioned, the panel about, as an example, the Companies Act 2013 and how it was not sort of as good as people would have expected it to be. And I, for example, know that there was this doubt with respect to put and call options, for example, and then those needed to be clarified in notifications, etc. So on the point, I think the larger point about sort of when laws are drafted, that they are done properly, because although there could be, sort of at the policy level, some big announcements or statements, it does create a lot of issues if the drafting itself is not at the, that could lead to further confusion, etc. So I was wondering if you've seen any steps in terms of what the government is doing, and also given that the parliament, debates don't happen in the way, one would expect over the sort of reviewing these laws when they are bills, whether there's any movement to ensure that we have acts which are clear and don't lead to more confusion than actually helping the process.
In fact, majority of the problems arose because of bad drafting. And two sets of things. One at the legislative level and the second at the policy level. Because a lot of powers have been given to the bureaucrats to develop policies, and and that's where we find a lot of ambiguity, because they are not written by professional lawyers or professional draftsmen. And as far as the legislations are concerned, what has happened, a number of cases we found that government gave up the practice of appointing a law commission. Traditionally, that was the system. Proper, hearings were provided, and then law was drafted with a lot of care. But in recent times, it's the bureaucrats who began to draft law and put it in the legislature for clearance, like direct taxes code. There was no law commission. Some 8-10, bureaucrats sat together and wrote whatever they wanted to write, and you find one after the other sections are constitutionally possibly not valid. Just to give you an example, direct taxes code is a serious law, right? Completely new act, income tax they wanted to have. And they wanted to, define total income, because income has to be defined. So they said total income shall be, computed in accordance with section 71. When you look to section 71, it talks of deduction for disabled people. So, this is the kind of thing that came in the legislation, and you feel really sad that this legislative drafting became a big menace actually. And what typically happens, laws are introduced in Finance Act in February, and budget comes, you have Finance Act, and then by month of May you clear it, and there's so much mess in the whole thing. So, you can go back to Finance Minister on only 1 or 2 or 3 important issues. In the process, about 8 or 10 other problems are not addressed, because people say if you go with 100 different things, you will not be paid attention to. So that's how this whole system has gone on a little toss. And I've been suggesting to the government that at least in cases where you have serious legislation, you must appoint a law commission.
Yeah, but just to
sorry
sort
for that.
of also add, I mean, I think that's a problem, and that probably provides lawyers their bread and butter in terms of, drafting concerns in Indian laws. But if you see our recent insider trading regulations, there's always, a sort of a gap between the cup and the lip. And they're trying to, if you see the insider trading regulations, there is a spirit form sort of regulation that is out there, where there are notes explaining the provision of the law, and explaining what the regulator really wants to achieve in that law. So I think is it a problem? Yes, it is. Are we trying to resolve it? Maybe not in totality, but are specific regulators trying to do something different? The answer to that is yes. And I think our takeover code and the SEBI insider trading would be one such example, where at least in the insider trading regulations, it's not just a law, but it's also notes to interpret the law, which may be one step in the right direction.
Yeah. So
Just to add.
Also to add to what Simon said, also what government is trying to do now, and this is very recent phenomena I have observed, is they have actually appointed a research agency to go and find out on what is the implication of law which they are planning to do. So recently I had an experience where the new law which the government is planning to do is on the new Product Liability Act and the Consumer Protection Act. The new Consumer Protection Act includes Product Liability Act as well as unfair agreements and other similar situations. So there I got a call from a research agency who is helping the minister and the parliamentary members to ask questions on whether this particular law is sufficient, what is missing, why it is missing, what exactly should be done, because the bill is out in public for people's comments. But there is a research which is research agency which is going and looking at it and giving inputs to the parliamentary to improve the existing draft bill. Now this is something which at least when I heard from them and they called me and says give me your feedback on this particular law, I was surprised because that's not what I have seen it happen in general. So maybe things are changing, as Simon said, as I have experienced, government is actually trying to improve it. But having said it, we still have to see good drafting coming up. We still don't see good drafting skills.
One good thing on the positive side a little bit, Security and Exchange Board of India and Reserve Bank of India are now inviting public comments on their biggest policy statements, which is a good thing. That process seems to have worked reasonably well. And but on the tax side, still there are some difficulties. You must have heard about POEM. POEM is not about poetry or otherwise, all of you know that. It's about place of effective management, which is the criteria that would be applied to determine corporate tax residency. Today it is primarily what is called incorporation is the test of residence for an Indian company or place of central control and management, wholly control and management. But now they want to replace that objective criteria with more subjective concept of place of effective management, and popularly called POEM. And look at what happened. POEM law was incorporated in income tax law on 1st of April. Law came into being, but they did not talk about it. Only in December end, on 23rd of December, Tax Department received a clarification, long clarification as to what is place of effective management and what not. And they said by 2nd of January, public should give all their comments. Now 23rd of December, when you're starting a vacation, I had to spend most of my Christmas vacation going through that particular law, unfortunately, because everybody is so scared of POEM nowadays, So they said up to 2nd of January, then they extended by 9th and stuff like that. Now you need some 30, 40 days at least for public to come and react to the whole thing. So there is little disconnect still at the tax department level. It's always been a little difficult for governments to deal with the tax department. But we see that at the same time some changes are also happening for good. So it's a little mixed bag. But today we have to move very fast as far as reactions are concerned. If any of you have anything to say, feel free to write to us, no problem. I'll personally take up. So I hope we can close this first session, and all panelists have given very valuable inputs, and I, on behalf of the firm, would specifically like to thank Abhijit for joining us today. May I give a little round of applause, and also request Ankit if you can present a small token of appreciation to Abhijit.
So I'm
for
the
joining
rank
us.
outsider. I'm the rank outsider.
That's good news, no? You're free to do what you insider trading is a little problem. So, yeah. Thank you very much. Thank you so much.